do our intro. So welcome everybody. Excited to have you in class today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center, and I'll be with all of you in the chat, gathering all your questions. So as we go through class today, please put all your questions in the chat for the Q&A, and don't worry, we'll get them there. Our Friday classes are so much fun because we get students from all over the country, all different age groups, here to meet top scholars and ask them all the questions they want on the theme of the Bill of Rights. But as Jeff already alluded to, our professor today is a huge favorite at the National Constitution Center. He does so much for us. We love talking to you. He is high school teacher certified. I'm going to count it as still in flux. But also we get to ask him about any question on the Constitution, so we can stretch it a little further today. So Professor Chemerinsky is the Dean of Berkeley Law School, and Jeff Rosen is our President and CEO. So without further ado, I'm going to turn it over to Jeff to kick us off and get us moving.
Thank you so much, Curry, and welcome, Erwin Chemerinsky. I put up my inspiring fake backdrop, which is the text of the First Amendment, which, Erwin, I haven't seen you since we installed this at the National Constitution Center. It came from the museum in Washington, D.C., and it's so meaningful to have these words inscribed in a 50-ton tablet at the NCC. And I would love to use our precious time together to ask you about the core meaning of the First Amendment over time, and then maybe to dig into each of its 5 clauses. And then we can see if we can talk about the rest of the Bill of Rights. But you're just a world expert on the First Amendment and would love to get your thoughts. Let me quickly set this up by saying that when we unveil the First Amendment tablet, I'm going to talk about Justice Brandeis's opinion in Whitney versus California, which identifies 4 separate purposes for protecting freedom of conscience. First, freedom of conscience is an unalienable right. Second, public discussion is necessary for full participation in democracy. Third, public officials have to be subject to vigorous criticism. And fourth, truth can only emerge in a combat with error in the public sphere. So that's Brandeis's take, but you have so many more. If I just began by asking you, tell us why the First Amendment matters and what some of the important reasons that the Supreme Court has recognized are, what would you say?
Let me start by saying what a pleasure it is to get to have this conversation with you. And I think you're absolutely right that Justice Brandeis's concurrence in Whitney versus California is the most eloquent explanation of why freedom of speech is a fundamental right that I found anywhere in the United States reports. It's interesting that you focus on all of the First Amendment. And I think what unites all of the clauses is a phrase that you used, freedom of conscience. It's about our religious beliefs in conscience. And of course, we can't have freedom of conscience if the state is going to coerce us into a different set of beliefs. That's why there's also a provision that there can't be an establishment of religion. But I think freedom of speech is about conscience. This is what Justice Brandeis was saying, because speech is the way in which we receive ideas, the way in which we formulate our own ideas. We can't have freedom of conscience if we can't receive information, if we can't express ourselves. But there's also the idea of the ability to gather together with others. We form our beliefs, we express ourselves, not in an individual way often, but as part of a group. And that's freedom of assembly. And we've got to be able to express ourselves to our government, because I think a core part of much of the First Amendment is democracy. You can't have a democracy without freedom of speech, without freedom of the press, and therefore there's also the right to petition government for redress of grievances. So the rights are distinct, but I think they're all unified by what you referred to as freedom of conscience.
Oh, what a marvelous way of bringing all those ideas together under freedom of conscience and showing us the way that it's exercised in different combinations in different ways in each clause. I'll share with you next how struck I was to discover that Brandeis seemed to be tracking very closely the same 4 reasons that Thomas Jefferson expressed in his original draft of the Bill for Establishing Religious Freedom in Virginia. Is that connection correct? And what was it about Jefferson's attempt to establish freedom of conscience that so shaped the core meaning of the First Amendment?
The context of what Jefferson said and what Brandeis said were very different, but the underlying impetus is remarkably the same. What Jefferson was speaking of was whether or not the state of Virginia could impose a tax to support the church there. And Jefferson and Madison very much opposed that. It was Thomas Jefferson who articulated the notion that there should be a wall that separates church and state. And the idea was, if we're going to have freedom of conscience with regard to religious beliefs, we've got to have a government that's secular, that's not pressing us to move in any particular direction with regard to religion. Now, Brandeis is speaking about freedom of speech, not about religion in Whitney. And yet I think the reason that there's a similarity between Jefferson and Brandeis is just what you and I are talking about, how both religious freedom and freedom of expression are united by this notion of freedom of conscience.
Absolutely fascinating. And what more should we know about what we're learning now together? That freedom of conscience unites all of these clauses of the First Amendment at the time of the founding. Were there other intellectual sources that inspired the founders on freedom of conscience, or paradigm cases in addition to the fight against taxes for religion in Virginia that we should know about?
Well, there are many things that preceded the United States Constitution. In England, in order for there to be a publication, there had to be a license obtained. And this then was changed. And Blackstone, who wrote very famous commentaries on English law, said, above all, what freedom of speech is about is no licensing from the government, what we would call today no prior restraints, where you can only speak or publish if you get advance permission. And I think that this was quite crucial to the framers of the First Amendment. One of the things that's interesting is if you look at the first century of American history, there are virtually no Supreme Court cases about freedom of speech, hardly any about freedom of religion. That the first major Supreme Court cases about freedom of speech don't come until the early 20th century. And there's really only one major Supreme Court case about free exercise of religion in the 19th century. You don't get that till the 20th century. Now, this is because at the time of the 19th century, the Bill of Rights was thought to apply only to the federal government, not to states. And the federal government was relatively limited in what it was doing during the course of the 19th century. And it's early in the 20th century, especially in some cases arising after during World War I, that the Supreme Court articulates a philosophy with regard to freedom of speech. There was a case called Abrams versus United States, where in a dissenting opinion, Justice Oliver Wendell Holmes talks about how there should be a marketplace of ideas. He says, let all ideas be expressed, and the good ones will hopefully triumph, and the bad ones will get refuted. He says the best remedy for speech we don't like is more speech. And you ask where this comes from. John Stuart Mill had argued for something much like that non-liberty. And then, as you pointed out, Justice Brandeis picks that up in his famous concurrence in Whitney.
Absolutely fascinating. Maybe tell us a little more about those battles against the sedition acts that followed World War I and what kinds of cases Holmes and Brandeis were objecting in.
These were so crucial in shaping the law of the First Amendment because these were really the first free speech cases decided by the Supreme Court. We forget now that World War I was terribly unpopular, and there were certainly many who supported it, but also many who opposed it. And one of the first cases to come to the Supreme Court about freedom of speech about a law adopted by Congress in 1918 that essentially made it a crime to criticize the draft of the war effort. The case was Schenck versus United States. Schenck distributed a leaflet in which he argued that the military draft conscription was involuntary servitude in violation of the 13th Amendment. Schenck got convicted for violating this law, got sentenced 10 years in prison, and it went to the Supreme Court. And the Supreme Court upheld Schenck's conviction. Justice Holmes wrote the opinion. It's where Justice Holmes said that free speech isn't absolute. There's no right to falsely shout fire in a crowded theater. He said the government can punish speech if there's a clear and present danger of harm. Now, I would think that Schenk's speech was the antithesis of a clear and present danger. There's not an iota of evidence that Schenk's speech had any adverse effect on military recruitment or the draft. But the court was willing, in the context of war, to give deference to the government. Another case decided that same year in 1919 involved the socialist leader Eugene Debs. He gave a speech to an audience of college students where he said, quote, "You are good for more than cannon fodder. There's more that I'd like to say, but I can't." For that, he got convicted under the 1918 Act. And again, the Supreme Court upheld the conviction. So these cases didn't set the tone of great protection for free expression. They instead were giving enormous deference to the government. And it's only several years after that that Justice Brandeis writes his opinion in Whitney.
Wow, so important to think about that context. And you've introduced us to Holmes's clear and present danger test. Much of the debate between Holmes and Brandeis in the court was how much of a connection you should have to prove, as you suggest, between the speech and any possible harm. And Justice Brandeis proposed a test that the court eventually adopted in the Brandenburg case in 1969, essentially saying that to punish speech, you have to show that it was both intended to and likely to cause imminent lawless action or serious injury. Tell us about that test and why it makes the US today the most speech protective country in the world.
You're absolutely right that the Brandenburg test is key. And I think you're also right that it makes us the most speech protective country. But I do want to point out that between 1919, when Schenck and Debs were decided, and Brandenburg in 1969, the court often failed to be speech protective. You mentioned, to start with, Whitney versus California. It involved a woman who was convicted just for attending the Socialist Convention. And the Supreme Court upheld her conviction, saying so long as the government's acting reasonably, it can punish speech. Or take Dennis versus United States in the early 1950s. It arose in the McCarthy era. It involved two individuals who were convicted just for teaching works of Marx and Lenin, organizing study groups. And the Supreme Court said, when the evil is as grave as overthrowing the country, it doesn't require any proof of likelihood or imminence. But then you get to what you pointed to, Brandenburg versus Ohio, now over 50 years ago, where the Supreme Court gave real meaning to clear and present danger. And as you say, the Supreme Court held, in order to punish speech as incitement, it has to be shown that the speech is intended, directed at causing imminent illegal activity, and is likely to cause imminent illegal activity. It's so much more speech protective than Schenck or Debs or Whitney or Dennis. And it's now been the test for over a half century.
It's remarkable. And it's so important that our students understand the test and recognize how speech protective it is. Well, I think we need to talk now about the many ways in which both the Brandenburg test and the reasons for protecting freedom of conscience that we're talking about are being questioned today in all sorts of ways. And just to pick one of the most obvious ones, so much of Brandeis's reasons for protecting freedom of conscience are rooted in a faith in reason itself. He says, as long as there's time enough for deliberation, the best response to evil counsels is good ones. And he has faith that in any combat with error and truth, reason will ultimately prevail. Many say now that in the age of the internet, there is no time for deliberation. Fake news travels faster than real news, and many lack faith that reason will prevail if it is allowed freely to spread. What are your thoughts about those criticisms?
I think the criticisms are apt, though I think the question is, what conclusion do we draw from them? Based on history, why believe necessarily that truth will triumph over falsity? Aren't there many instances in history where falsity survives, or at least survives for a long period of time and does great harm? And you're right, in the context of the internet, there's now the ability for false information to be immediately transmitted and cause great harm. But to me, the question is, well, what then? And to me, the question is, do we give to the government the power to decide what's true and what's false and to punish and censor what's false? I don't want the government to have that power. And the conclusion that I draw is the reason above all we want to continue to protect free speech isn't faith that truth will triumph for falsity, but tremendous distrust of government power. And I don't want them to have the authority to decide what's true and what's false and be able to punish and censor what they don't like.
So powerfully put. Now, of course, we turn to the reality that today platforms like Facebook and Zoom, the one we're on, and Twitter have more power over speech to some degree than any king or president or government. And there are similar calls on the platforms to restrict fake speech and to decide what's true. Granting that they may have the technical legal authority to do that, what would you say to the argument that the same principles that prevent us from trusting the government to make those decisions for us would also deny the same power to a private platform?
I think this is such an enormously difficult issue, and I struggle to think through and don't have answers to it. Now, you're right in pointing out that since Facebook and Twitter and YouTube are private entities, the First Amendment doesn't apply to them. They get to make their own choices of what they're going to carry on their platforms. And I think everyone should realize they make those choices every day. They're constantly excluding speech that's child pornography. They're constantly excluding speech that they regard as incitement of illegal activity. They're constantly excluding speech that's false and deceptive advertising. Now, the question is, should they go even further? Should we require them to go even further? Or should we limit their ability to do this? Remembering that any government regulation of these entities, since they're private, also has to meet First Amendment scrutiny. It's such a double-edged sword. On the one hand, social media has brought us the golden age of free speech. It has so democratized the ability to reach a mass audience. Used to be you had to be rich enough to own a newspaper, get a broadcast license to reach a mass audience. Now, any of us with a smartphone or access to modem in a library can reach a mass audience. Part of what free speech is about is access to information. We have access to unlimited information now through social media and the internet. On the other hand, social media and the internet makes it possible to disseminate false information in a way that's never occurred before, ability to harm reputation, to ruin privacy in a way that's never existed before. How do we mediate this? No one's come up with an answer to this point.
So true, and you so well articulate the difficult arguments on both sides. But just for the sake of being provocative, what does Brandeis's and Jefferson's view of freedom of conscience tell us? If freedom of conscience is a natural right that comes from nature or even from the creator and not government, and no one can try to tell me what to think because my thoughts are not even the product entirely of my own voluntary choice. They're the product of my reason and the evidence processed by my mind. Wouldn't the same natural right be at least morally enforceable against private platforms as well as government? And I'll just say that would make me suspicious about giving any entity, whether private or public, the ability to tell me what to think.
Of course, any restriction on what information we're able to receive, what views we're able to receive, has implications for our thoughts and therefore freedom of conscience. The difficulty, as I was alluding to, if the government tries to regulate Facebook, Twitter, YouTube, there's a First Amendment issue because it's the government regulating private companies. And what do we want the private companies to do in terms of moderating speech? And what do we want the government to require private companies to do with regard to moderating speech? And some of what makes this complicated is the enormous quantity of speech that's put on Facebook and Twitter and YouTube every day. I think the most important thing to say is we're not dealing here with a difference of degree with regard to the speech issues that we faced earlier as society. social media and the internet are in kind different than any media that have ever existed. They're the most important development with regard to speech since the printing press. And we're only a couple of decades into it, so it's not surprising that we don't have good solutions yet, but the questions are so important and so difficult.
I'm learning so much from the discussion. I'll venture my own struggles with this question, but my instinct ultimately to conclude from history that I want to maintain the Brandeis's and Jefferson's ultimate faith in reason, that despite all of the challenges posed by social media, the entire success of our system and of the Constitution itself is founded on the ultimate sovereignty of the individual reasoning mind, the illimitable freedom of the human mind, as Jefferson said. And I think I'm inclined to maintain a faith that left free, the individual mind will indeed find ways to govern in a productive democracy, as long as speech remains free and we only punish speech that's intended to and likely to cause imminent violence. But others feel differently. What are your views?
I'm very much with you, Jeff, on this. I think we have to have faith in reason. What's the alternative to faith in reason? Is the alternative to put faith in the government to determine what we can read and hear? Surely that's the antithesis of what the First Amendment and the Constitution are about. But we've got to realize the ways in which the internet can further our faith in reason and undermine our faith in reason. The internet can give us access to so much information in a way we never would have had before. We can be so much better informed. But the internet can also give us false information of a sort that we've never had. Think of deep fakes, where it looks like we're seeing something that's genuine, that's truly false. And imagine deep fakes right before an election. How do we have faith in reason when what we're receiving as information is so polluted? So I share your premise of faith in reason, but I also think internet and social media further it and undermine it simultaneously.
Very powerfully put. There are also challenges to the Brandeisian faith that speech should only be regulated if it's intended to and likely to cause imminent violence from those who are rightly concerned about other values like equity and dignity. And some say that to protect the dignity of vulnerable groups, that speech that demeans them should be regulated, even if it's not intended to and likely to cause imminent violence. How should we think about those claims?
We have to start by recognizing that speech of the sort that you mentioned, hate speech, causes real harm. We've been talking about the importance of speech. If speech had no effects, it wouldn't be a fundamental right. And the effects can be good, but the effects can be tremendously harmful. And there's many ways of dealing with hateful speech, but I don't think the response generally can be to punish it and exclude it from the First Amendment. In part, because I think there's an inherent vagueness problem. What do we define as that hateful speech? Almost every European country has a law that prohibits hate speech. It defines hate speech as speech that intimidates or degrades on the basis of race, sex, religion, sexual orientation. What do we mean by that? How would that ever meet our First Amendment test? Over 350 college universities adopted hate speech codes in the early 1990s. Virtually everyone to come to court was declared unconstitutional, usually on vagueness grounds. Also, experience should cause us to be cautious. When there have been these hate speech codes in the United States or laws in Europe, they're usually used against the very people we want to protect. When the University of Michigan adopted a hate speech code before it was declared unconstitutional, every enforcement action against it was against Black or Latinx students. When England adopted its first hate speech law, the first prosecution under it was against a Zionist group, with the prosecutor saying he thought Zionism was a form of racism. But maybe most of all, Jeff, my answer to your question is, under the First Amendment, all ideas and views can be expressed, even very offensive ones. And therefore, hate speech, because it expresses an idea, is protected under our Constitution. There need to be responses to hate speech. If it occurs in my law school, I have an obligation to speak out against it as a dean. But the response, I don't think, can be punishment.
such a clarion call for the shining integrity of the traditional faith in reason, and in counter speech is the best response to hate speech. And yet all of the pressure seems to be on the other side, and from the efforts on the college campuses that we see to shut down hateful or unpopular speech, to efforts in legislatures to ban books that some consider offensive, both on the right and the left. We're just seeing overwhelming pressure to restrict supposedly hateful speech. And since so much of it is coming on social media and in the private sphere, much of it will not be subject to First Amendment challenge. Do you perceive a gap between what the First Amendment requires and what people on the net are demanding?
Yes. The impulse to censor the speech we don't like isn't new. It's existed throughout American history. It's existed throughout world history. And of course, there are those on the left who understandably don't like hate speech and want to shut it down, or other ideas they find offensive, they want to shut down. And then you're right, there's people on the right who want to shut down speech, such as teaching of critical race theory. This, to me, can be tied throughout American history to the impulse to censor the speech we don't like. And it becomes so important then that we educate our students, our population, about free speech and why it's a fundamental value. That's why I so applaud everything you do at the National Constitution Center, because it really is about educating people. We're in a society where we don't generally do a very good job of civic education. More people can name some of the seven dwarfs than can name Supreme Court justices. And so I think the only way in which we can counter the impulse that you and I are describing is through civic education and helping people understand why my speech will be protected tomorrow only if I safeguard speech that I don't like today. We don't need free speech for what we like. We'll let that occur anyway. We've got to have free speech for the messages we don't like.
Hear, hear. Well, I think among the most important civic education functions we can provide is to educate our friends who are watching, all of you who've taken time this Friday to learn about the amendments, about the core purpose of the First Amendment. I see a great comment about the fact that we're just going to get through one amendment, not all 27, but there's no more important amendment and no more important teacher to educate ourselves about its core meaning. Erwin, what else about the First Amendment do you think is urgently important for our students to know so they can make sure to maintain its values and protect it?
I want to highlight something I've said in passing a few times. I think what also unites the provisions of the First Amendment is distrust of government power. Think about the structure of the First Amendment. No law respecting the establishment of religion, not wanting the government to put its enormous power and influence on behalf of a particular religion. Free exercise of religion, not wanting the government to be able to dictate a religious faith or a religious beliefs. When I think of freedom of speech and freedom of the press, it's about not wanting the government to decide what's true and what's false and have the power to censor or punish what it deems to be false. I think that freedom of assembly and the right to petition government for redress of grievances are also about not wanting government to be able to keep people from getting together for expression, not wanting the government to be able to keep people from exercising their democratic rights to urge change in government and change in government policy. And I think this often gets overlooked when we talk about the First Amendment.
Tremendously important, that mistrust of government power. I'll share with you my excitement to have found recently that the source for both Jefferson and Brandeis's memorable phrase that people should have the freedom to think as they please and speak as they think came from Cato's letters written by the Whig critics of the king and the ministry of England, who had that distrust of government power that you talked about. Maybe you brought us back to the revolutionary faith of the colonial era, but maybe say a little bit more about how that distrust of government arose at that historical period.
You're absolutely right that it was a distrust in government that was so important. I mean, it started in England before we got to the United States. I mean, the Magna Carta is in sense embodying some of what we're talking about. The Enlightenment in Europe is about what we're talking about. The idea that reason should replace religion as the basis for our decisions. And that's embodied in the Constitution. The Constitution doesn't begin by saying, based on the powers given by God, we're creating this government. It says, we, the people, are creating this government. And that, I think, is so important. You don't find invocation of God or religion anywhere in the text of the Constitution. They really saw themselves as creating a secular government based on reason. And that's why the First Amendment is so important, because if there's anything that embodies that faith in reason, it is the First Amendment.
I'm tempted to say amen. It's just so inspiring to hear you articulate the founders' faith in reason. When you know that the Constitution Center is nonpartisan and we're not allowed to take positions on contested questions, but I feel confident that the principles we've talked about today, which are rooted in our constitutional history, expressed in the text of the Constitution, and recognized repeatedly by unanimous or nearly unanimous Supreme Court majorities represented by justices of all sides, represent a settled and accepted meaning of the First Amendment that we can champion for our students. Do I have that right? And can I encourage the students to embrace these principles as a persuasive interpretation of the First Amendment?
I sure hope so, because I believe that the commitment to freedom of speech, the commitment to freedom of religion, the more general commitment to freedom of conscience isn't Republican or Democrat. It's not conservative or liberal. It's something that we all should agree to is a bedrock in our society.
It is indeed. And I'm going to turn the Zoom over to Curry in just a moment, but I'll just say, students and teachers who've been so privileged to listen to and learn from Professor Chemerinsky, please recognize that the principles that both of us are urging you to embrace are hotly contested principles. They are questioned and under challenge from all sides every day. And you'll see this in your own classrooms and campuses and throughout the public square. So that's why it's so important to listen closely to what Professor Chemerinsky is saying, to learn about these principles so that they are accepted by your own reasoning minds, so that you find them a persuasive interpretation of the First Amendment and of the rights that you hold as a reasoning human being, and you feel as motivated to defend them as Erwin and I do. Thank you so much for this wonderful discussion, Erwin. I really think you summed up the core meaning of freedom of conscience in the First Amendment so beautifully. And now I'm going to turn it back to Curry for a few final questions from our great students.
I think it's pretty poignant that we spent, most of the time or all of the time on the First Amendment, as Madison would say, would be the amendment above all others. So I think it makes complete sense. There's a couple questions from our students that I thought were fantastic and really unpack a little bit more. So Niels asked, the right to petition, why has that fallen to the wayside and not to be really used the way it once was in our country?
It's been subsumed in what's protected by freedom of speech. The same thing as you don't find cases very often about freedom of press that's separate from it because it's been encompassed in freedom of speech. Freedom of speech has been given a sufficiently capacious meaning that it includes what we protect under petition. It includes what we protect under freedom of the press. It doesn't mean that they're not valued. It just means that they've been really incorporated into our concept of freedom of speech.
Awesome, thank you. Now, the entire theme of this class was really balancing the danger of taking the First Amendment too far, the reason to be worried about your government and really understanding the power of the First Amendment, but also the danger of it at the same time. Like, don't take it too far. This is the whole point of it. Don't give the government too much realm. And I love this idea that you didn't leave it just at that. You didn't leave it at just be careful. You said, no, it's your job. It's your job to do something. So the idea that we in this country And with this Constitution, we expect people to be alert, to people to be a part of the system of solving issues in our society. So one of our students said, with this idea of Facebook and Twitter and social media really having too much free reign, we don't want the government to do it. But what if we set up juries? And a jury or a civil, his statement was it was Christopher, a civil tort system within it to be able to kind of manage this system. How could the people of our country step in and respect the beliefs, but not ask the government to do so?
The difficulty, of course, with that is tort law is created by the government. Whether it comes from a statute or it comes from the courts, tort law is still law. And we've seen, for example, if tort law makes it too easy to hold speakers liable for defamation, there'll be an enormous chilling of speech. And so if we make it too easy to hold Facebook and Twitter and YouTube liable for the speech that they have, then the speech over those media will dry up. And how do we then protect those media as avenues for tremendous speech if we allow tort liability? And there's already some tort liability, but it's limited by a federal statute, Section 230. Liability is limited by the First Amendment. So I guess my bottom line question is, how are we going to define what that tort liability is in a way that would still protect freedom of speech? And that's what I worry about.
Amazing. And I think so much of these conversations need to happen constantly. And I love that they're happening with our students who are digital natives and have lived this their entire life. And it's a part of their system. And I so appreciate you in every scenario laying out the benefits and the dangers of each scenario. I love that you started off with social media has made us so much more engaged with each other, with communities, and building things. And then here's the problem with it. And then how will we solve that problem? So fantastic class. Thank you so much as always. We'll be bugging you soon for our summer teacher workshops, just a warning as we go through and wrap up this class. And let me turn it back to Jeff to kind of pull us all together, but really an unbelievably powerful class and so important to understand the Constitution from 1787, the Bill of Rights from 1791, and our conversations today. They're all connected.
Absolutely, Curry. Erwin, what a joy to be able to talk about the principles of the First Amendment with you and with our students. And dear students, your Jeff work for the weekend is to read more of Professor Chemerinsky's books. He's written illuminating and meaningful books about the topics we've been talking about, including free speech on campus and the religion clauses of the First Amendment. He's written the leading textbook on constitutional law, which I teach when I teach constitutional law. So you've just been so privileged to hear and learn from America's great First Amendment and constitutional expert, and you can give yourself the treat of learning more by reading more of his superb and illuminating scholarship. Erwin Chemerinsky, on behalf of all of us, thank you for giving us this time and for teaching us so much and inspiring us to learn more. Thank you.
Thank you. Truly my great pleasure. Thank you.
Wonderful. Thanks to all. Have a great weekend, everybody.
Thank you, everyone. Have a great weekend, everybody.
Thank you. Bye.
Fantastic. Thanks, Jeff.
Thanks. Bye.
It was a very thought-provoking class, Vicki. I agree. There are lots of notes on my notepad today. Wonderful.